Again, just stay in your role. When you're on the witness stand, don't be argumentative. Doesn't mean not to be forceful, but you don't argue. You don't start asking questions back at the attorney. Well, what do you do? Or how would I do it? No. You answer the questions that are posed. If you don't understand the question, tell them or tell the judge, I don't understand the question. There's nothing wrong with that. Attorneys go to law school to learn how to ask questions that nobody understands. And so really what you need to do is say, I don't understand it. Or if they're putting facts into a question that you didn't rely on. No, that's not what I said. What I said was, and you tell them what you said, and then you can answer the question with your correct facts that you've already put in. And that all goes to credibility. You have to be credible. Credibility is determined by the trier of fact, by the judge at that time. Remember, you got the appellate division and the Supreme Court. They're going to defer to the judge, the trial judge's determination of credibility. If I find that you're not credible, you don't have a chance. I'm going to tell you that right now. You're really not going to have an opportunity. And the only way that I determine credibility is by looking at you in the courtroom. I look at your body language. Are you effective in your testimony? Are you able to answer the cross-examination? Do you know what's going on? Do you make sense? You're not going and taking extreme positions. That's the important part of credibility. Because remember, as I say, the appellate courts, they're reading the transcript. They're reading the words. They don't hear the inflection in your voice. They don't hear the confidence in your voice. They don't see any of that. The trier judge.
I have a question. I've always wondered how a judge reacts to when a witness is asked a simple question, and some witnesses, it's not going to help. They made a mistake. I think you're better off to just say, I screwed this one up. But there's some witnesses that think this long-winded answer when it's a yes/no. They just don't want to say no.
No,
it doesn't help, right?
Answer the question. You can always explain your answer. If the attorney that's asking you the question about a mistake that you've made, and you say, yes, I made a mistake, but, and the attorney says, no, I just want to answer no, yes or no answer, that's fine. Your attorney is going to have an opportunity to come back on redirect and ask you, now, you said that you made a mistake in that area. Can you explain to me what the mistake was and how you corrected it? So you're always going to get that opportunity. But if you try to be argumentative at the first time, you lose some credibility. And if you try to explain the error that's going on to be compounding that error, that's not going to help your credibility at all. Do you know the subject matters of credibility? As Chuck said, inspect your properties. Be sure you've looked inside, outside, you've walked around the property, you know what's across the street, you know what's down the street. One of the best appraisers I know, no offense to anyone in this room, but would go out the night before trial and drive around for a half hour, 45 minutes on every one of his comps and the subject. He knew that area better than the people that lived there for the period of trial. And he testified all over the country, and that's exactly what he would do. You've got to be, because you're credible. Yes, across the street is a park. It helps if you know what's going on. So you got to know your subject. If it's income-producing property, as Chuck was saying, get the rent rolls. Look at them, study them, see what they say. Look at the income and expense statements in the New Jersey case that says you should look at a minimum of 3 years. If you don't have at least 3 years' worth of income and expenses, you've got to explain that in your report and what you other relied on. Did you use other comparable properties, income and expenses that you have? And why do you look at that? You want to get rid of those spikes, those valleys. You want to stabilize the expenses over a period of time. You want to look to your lease. Is it a new lease? Is it a renewal lease? If it's renewal, was the option to renew in the original lease, and did that set the rental to be paid during the term of the option? Or did they go back out and look to market and see what's going on in that lease? So you've got to do all that due diligence, because that goes to your credibility. If you didn't read the leases, you're going to have a problem. How are you going to know what the CAM charges are? How are you going to know who's paying the taxes? Oh, I looked at a lease abstract. Sometimes that's okay, but most times not. Comps. Very difficult, and I know in income-producing property, it's extremely difficult to go up to a landlord and say, oh, by the way, I'm using your property as a comp. You want to give me your rent rolls and give me your income and expenses so that I can take a look at that. It's very, very difficult. But you need to make those efforts. You need to at least inspect the properties, look at the board downstairs, see who the tenants are, see if you know any of the tenants in there. Try to get copies of the lease. Do what you can in your due diligence, because that goes to credibility. What did you do? How did you look at it? What did you look at?
And add an extra 0 to your appraisal fee.
Yeah, it's expensive. There's no question about that. You just gotta be ready and be able to respond on cross-examination. You should work with your attorney day, 2 days, 3 days before, not on your direct testimony. That's the easy part. You know what you're going to say. Hopefully you've done all the due diligence and you've put that together. The real trial starts when cross-examination comes in. That's when now the test, you're put to the test. Did you really do what you said you did and do it correctly? We talked a little bit before about net opinions. Net opinion is, it is because I say it is, meaning you didn't do your due diligence. You have to have something to rely upon. You have to have your comp sales, comp leases, cost manuals. Without the facts and data, an opinion is unsupported by factual evidence. It's not going to get in. As I indicated before, yesterday I had a trial. The appraiser did not undertake all of the due diligence that was necessary, and in particular, didn't verify any of the information other than to talk to the assessor and do a drive-by. The assessor is not the primary data source. The assessor knows about a sale. They may know about some income and expense statements. In New Jersey, we have what is known as Chapter 91, where the assessor can ask income-producing properties to send to him or her all of the income and the leases and expenses associated with that property, and you can come in and look at it. But did you do that? Did you find out what's going on? If you don't have anything in your report that you relied upon and you said, oh, I just talked to the assessor, you have nothing based on, it becomes a net opinion. And net opinion is not admissible. So you've spent all this time and all this effort putting a report together, and you're not even going to get it into evidence. And so the judge is not going to have that to consider in coming to the valuation issues. We talked about before about examples that I had here were really about the gross livable area. The appraiser would give me just a number. It doesn't tell me where he got the number from, or the bathroom adjustments. Those are things that need support, an important support. You can also have a net opinion by not having sufficient market data. And by this, what I mean is that you only look at the subject property that's income producing, and you take the leases that are in that property that are contemporaneous to your valuation date. And you say, oh, they're close to my valuation date, that is market. And don't go out. If you don't go out into the market to check that and measure that against the lease that has been negotiated, you're not going to know. And I don't like to do this too often, but I'm just going to read a little something to you. An excerpt out of an appellate division decision talking about the information that the appraiser didn't do. It says the property owner's expert witness obtained all the data upon which he relied from the property owner's attorney. First mistake. The attorney did not testify. The witness received no information from the court-appointed receiver or the management company. Didn't go and talk to anybody about what was going on that had been operating the property. The tax court's opinion reads in part as follows. The data, as I indicated from the subject, was incomplete, and there was a need for interpolation. The judge had to interpolate some of the data. Expert's knowledge of the data, as we've indicated, was limited. He got it from the lawyer. He was uncertain of its accuracy. He had no discussions with those who assembled the data or with those who were managing the property during the years in which the data was generated. He had only a rudimentary explanation, and one that I find unsatisfying, as to the rapidly changing categories or rapidly changing numbers for various categories of income, in particular, as we noted, the vacancy factor and the sewer and water charges. So there was a big change in vacancy, and the sewer and water rates were going up and down because the property was occupied, wasn't occupied. Tenants moved in, tenants moved out. But the appraiser didn't do any of the information, just relied on what the attorney gave him. Case was dismissed by the tax court. The appellate division upheld that dismissal. And the line here that I find most interesting here is, although the plaintiff's expert analysis of the data may be adequate, the data that they had and relied upon was adequate, I don't reach that issue because the data he relied upon is inadequate under the standards that we set forth, the whys and wherefores. So the judge looked at it and said, yes, the way the appraiser did it was good, but the data was inaccurate, was unsupported, therefore the analysis was no good. And the appellate division even talks about that case and says the property probably was overassessed. But because the appraiser didn't support, it didn't happen. Same thing with your sales. You're doing comparable sales and income-producing properties. You've got to go out and you've got to talk to someone who was responsible in that sale. The broker, a principal, one of the attorneys. Without verification, we don't know if it's an arm's length transaction. The dollar may look good, but you need to speak to somebody that's responsible or was responsible for that property. Very, very important. Without verification, I can't say that was market transaction. Without market transaction, I can't come to a conclusion of values for your property. I hear appraisers say to me, I have experience. I looked at that. I know it. Experience is very valuable, and I measure and treasure the experience that the appraisers give us. But the value is diminished when the record is void of any data of that sale that an expert relied upon to arrive at his adjustment. You've got to go out, you've got to speak to people. Reasons why you do? Because I've seen cases come up where the property, it looked like an arm's length transaction, but really in reality, when you did a little due diligence, there was a bankruptcy, there were multiple properties included in that sale. There may have been from a mother to a daughter, or a daughter to a son, or brother, a divorce proceeding, which may not come off the deed. You may just see the names, and they may have already changed their name as part of the divorce. So you're not going to know it was Smith to Smith when it says Smith to Jones, but it very well might be Smith to Smith, but for the divorce proceeding. So you need to look at that and investigate and study all those.
Just real quickly, the underlying purpose for all of these standards is if it's your burden, if you're representing a taxpayer on your appraisal, to convince the judge what your number is. And if you're just taking a lot of these things that you're assuming the MLS is correct, doesn't mean it is. And it's really up to you. If you do all those things, you're going to be much more successful.
The MLS does have some, at times, incorrect information. That does happen because we don't know who's entering that data. The property record card, at times, does have incorrect information. So you just can't accept the square footage on buildings. I have cases coming before me where the two parties can't agree to the square footage. The appellant, the taxpayer, is using the square footage that's in the property record card, and the town has a higher square footage. Why? Because they went out and measured the property for that appraisal. The independent appraiser came in, went out and measured the property. And what do I do? Who do I believe?